Okay, in the existing Section 85 of the National Credit Act, of course, a court, in respect of a matter that is hearing, where there is an allegation of over-indebtedness, may of its own accord refer a consumer to a debt counsellor for debt counselling and or debt review. All that happens now is the court also has a right, if they find that this consumer may qualify for debt intervention, to refer the matter to the NCR for consideration. All right, then just a reminder again, the existing Section 86 as amended will now again be amended. In the existing 86, we could ask the Maj Court to extend the period of the agreement and thus reducing the amount of each payment accordingly. We could also ask, and although I said this happens very seldom in practice, that a specific debt or payments for a specific debt be postponed until a certain date, in other words, for a specified period, a sort of a payment holiday, if you wish, or both, a combination thereof. Now, however, the magistrate becomes authorized, and I was surprised that this was not really referred back to Parliament or even the Constitutional Court, because listen here, the magistrate will now be able to determine a maximum rate of interest, fees, or other charges. And the test there is that it must be fair and reasonable. And then for that period of 5 years. So here, unlike was decided in cases such as Nedbank versus Norris, Nedbank versus Jones and others, where an order made by a magistrate to the effect that interest rates be reduced as proposed by a debt counsellor was ruled to be ultra vires. The magistrate is a creature of statute and cannot unilaterally or against the terms of an existing agreement that is the subject of this, cannot just of his own accord then change it. Here, the magistrate now is specifically given the powers to do so. You can see declaring interest rates, costs and fees to be reduced and even to be zero rated. And this then flies in the face of the existing case law, Norris and Jones and Nedbank, simply because the existing Section 86 did not provide for that. Obviously, even today, before the implementation of this, parties can agree, credit provider and the debtor, and they do, to reduce interest rates or to zero rate interest rates. But it can't just happen because the debt counsellor suggests that in the absence of an agreement. The powers of the NCR taking on now the job of debt counsellor in these limited cases, as well as the powers of the tribunal, is further expanded, as we'll see now. This is also, all of these measures, once it becomes operational or comes into effect, the minister is required to review this after a period of 4 years, or within a period of 4 years. Once the consumer under debt intervention has satisfied all the obligations under the credit agreements as amended, or demonstrated financial ability to in future do so, and provided there are no arrears in terms of the rearranged agreements, then the NCR is authorized to issue a so-called clearance certificate. Very much like the debt counselor now, once all the debts, save for long-term debts and mortgages, have been paid, and there's no arrears and so on, can issue a clearance certificate, and that's the only way. We'll get to that later, but that's basically the only way that you can get out of debt counseling once you have satisfied all the obligations under all the agreements that form part of the debt review process, except for mortgage and what they call long-term. And some magistrates have a view that vehicle finance is long-term. Others do not agree with that. We've had an indication from the NCR by way of a guideline that vehicle finance is not regarded as long-term, but I couldn't find a specific court case. Nobody has taken this for a declaratory order or the like to the High Court. All right, so now the tribunal, which previously could not hear these matters, is now empowered to do so, and further empowered in the process of considering this debt intervention. You consider all the agreements, of course, that this consumer is party to, and also can now declare credit agreements void because of it being unlawful in terms of Section 89 of the Act. And you could also have the tribunal now declaring certain provisions in credit agreements before it unlawful provisions. So it's basically the functions that courts have now. You could now also find at the National Consumer Tribunal. And I think this added workload to the National Credit Regulator, as well as to the National Consumer Tribunal, is perhaps one of the reasons why this act has not been implemented at this stage. Okay, and then where, because of lack of income over and above the income needed for basic necessities, we cannot rearrange the consumer's obligations. There's simply not enough money. The tribunal now has the remedy to suspend those relevant obligations and for a period of 12 months, and then should the situation not have improved, for a further period of 12 months. And then if the situation is still not improved 24 months later, the tribunal may then declare all or part of the obligations extinguished. So now we're back to that Section 1 definition of extinguished. All the rights and obligations then are extinguished, and you cannot collect any longer. All right, then some very practical stuff. The tribunal normally consists of a panel of 3 members. Here, a single member can deal with these debt intervention measures. Of course, very much like the position now is with the debt counselor, but then also with the match court, you could also have people applying for debt intervention, like with debt counseling, who simply are not over indebted, who do not qualify. In other words, we say that they are not in a position unable to satisfy all their obligations. They must just budget properly and perhaps leave certain non-essential expenditure or so-called luxurious expenditure. Again, the qualifying credit agreements may be suspended for a period of 12 months and then further 12 months. And you could also require the intervention applicant to attend a financial literacy program. As far as I know, no development in this regard of such a financial literacy program, which would be a good thing, because often we find that lack of knowledge, lack of experience or exposure to the credit market amongst many of our people lead to them entering into agreements that they simply shouldn't have entered into because of a lack of knowledge or experience. And then, of course, often those people are also the victims of all sorts of unscrupulous money lenders and financiers and so on, because they're easy targets and easy victims. And I think this is also part of the swinging of the pendulum in favor of the consumer. You know, for many years we've had a system where the credit provider basically had all the rights, or the lessor, or the employer, and the employee or lessee or consumer had very little to say. And I think in reaction to that, the pendulum has swung quite a bit to the other side. Some people would argue too far to the other side, that now it seems to be extremely difficult for a credit provider or a lessor to enforce their rights, or an employer for that matter. Very difficult to get rid of somebody or to evict somebody from a house. And part of it is because of the Constitution that demands that the rights of disabled people, minors heading households, women heading households, or elderly persons should be taken into account. I always smile when I see this, and I think, well, at least now that I'm getting older and I have a bit of a problem in my one hip, I may qualify as a disabled. I am an elderly person, and of course my wife is heading the household, so I would, on 3 of the 4 grounds, would be able to apply for to get help because of these factors. Other things to consider, of course, is reckless credit. The circumstances of the respective parties, were the ability to pay taken into account. And then also other things such as the debt intervention applicant, the consumer, being able to increase existing income. Often we find that people do not know that they qualify for certain rebates or certain assistance from the state. Although that has changed to a very large extent due to COVID, most people are now fully aware of what they can and can claim by way of assistance. All right, so there's just a summary again. And then, of course, with these agreements now being suspended for periods, or one could ask the question, how about prescription? Would prescription stop to run? And the answer is yes. In terms of the debt intervention, prescription will not continue to run, although there is now no payment made. It will only start or be completed a year after the day on which the suspension ended, to avoid people then raising special pleas once you can again start collecting of special pleas of prescription. Okay, there's the summary again, the effects. So such a consumer may not enter into new credit agreements except for a debt consolidation agreement. Now, debt consolidation simply means that I apply to a credit provider who will then grant me a loan, provided that that loan is used for the sole purpose of satisfying my obligations under the other credit agreements, those that I cannot satisfy. So then it is not regarded as reckless credit, because this is not additional credit to somebody who's already over indebted, but to cure the over indebtedness, and now is simply owing somebody else money apart from the previous credit providers, which have now been solved or settled. And sometimes people do this, and they obtain these loans to get out of their debts, especially in instances where the consolidation loan provides lower interest rates than the existing credit agreements that they settled with. So that could be one of the reasons. And yeah, I recently came across people advertising that they can get you out of debt counseling or debt review. And I was wondering, how do they do that? And then it turned out it is not a debt counselor as such, or an attorney as such that advertise these services, but a credit provider. And what they had in mind was getting you to obtain a consolidation loan from them. They pay your existing debts, and you then can be out of debt counseling. Obviously, once you receive that notice from the NCR, you cannot, as credit provider, exercise any of your rights or enforce by litigation or other process any of your rights until such time as the NCR has either rejected the application or the consumer is in default under the new credit agreement, or they found that he is not over indebted. Okay, and then of course, very much like the position is now, if you're under administration or if you're under debt counseling, a credit provider may not enter into a credit agreement with you, other than, as aforesaid and explained, the consolidation agreement. That would amount to an unlawful agreement. It would also, of course, constitute reckless lending. And thus, it could also be punishable by way of an administrative fine, over and above the fact that you will not be able to enforce such an agreement, save perhaps by way of action based on unjustified enrichment, for instance. But you cannot, if the contract is declared null and void, you cannot, of course, enforce any aspect dealt with in the contract. So you won't have any remedies flowing from the contract. Okay, the same would apply to the applicant, of course, the consumer. If he fails to indicate when asked to do so to the credit provider that he is already receiving debt intervention help, you cannot now enter into the new contract and then claim that I'm under debt intervention. Somebody asked me a question like that, but we'll get to that when we go to the questions section. Again, by way of repeat, just to make it very clear, if that credit agreement is extinguished, there is no way in which you can collect on it, enforce it, be it for the whole amount, be it for a portion. It's written off in a statutory manner. It doesn't exist anymore. Okay, I think that is an overview of the Act. You are welcome to send me questions regarding this, and I will try and answer them as soon as possible. I think the initial reaction from credit providers and so on was very negative, especially regarding extinguishing of debts and lowering of interest rates and costs and so on. But I think gradually they realized that this will only be a small portion of people that would actually qualify for debt intervention, only in those limited unsecured credit transactions, unsecured credit facilities and so on, and only those people earning less than 7,500 Rand per month on average. So it should not be too, and then it also begs the question, if you have people earning less than that, not able to pay the installments in your credit agreements, unless if there was a dramatic change in circumstances, perhaps initially it constituted reckless credit as is. My bigger worry is that credit providers, this type of intervention might be very hesitant to grant credit to poor people or people with low income. And often, I mean, credit is a necessary cog in the economy and also in your personal life. Very few people that I know of, myself included, would have had ownership of a house or a vehicle if it was not for credit. Very few people that can buy these things cash, especially in the beginning of your careers and so on, when perhaps you need it most. Anyway, so there might be reluctance now to grant credit to those people. Okay, then our annual update on case law. Now, as I said yesterday, because of COVID and the lockdown and the situation in many of the courts, we've had very few cases that we could actually say should be included in an update where the position dramatically changed or so on. So I'm afraid this year, unlike in previous years where we could discuss numbers of cases, it's not going to be the case. The other thing is, of course, as we go along with this badly drafted act, which in the word of the Supreme Court of Appeal makes its interpretation extremely difficult, as we go along with litigation and decided cases and SCA cases and constitutional court cases even, it is starting to get sorted out so that we will have less litigation of the type that one will have to feel the need to report to delegates like yourselves. Okay, the one important one that I wanted to talk to you about was the case of Standard Bank and others versus Tobiane. And there's similar matters in Nedbank versus Great Ghana and other related persons. Okay, so by way of a directive, the Judge President in Gauteng, Judge Mlambo, asked the full bench to pronounce on the concurrent jurisdiction of MAJ and High Court, and also in certain instances the concurrent jurisdiction of the provincial division with that of a local division. And the question was answered by way of promotion of access to justice in the context of the MAJ Court and the High Court and the National Credit Act and so on, that where the monetary value claimed is within the jurisdiction of the MAJ Court, this should be instituted there. unless if you have a prior application to the High Court where you get leave to hear the matter in the High Court. And furthermore, the High Court would be entitled to transfer a matter of its own accord to another court, i.e. the Match Court, or even to local divisions of the High Court, if it felt it is in the interest of justice. Okay, so the position was then that I always had a choice to either institute action in the Match Court or High Court, provided that there was either a consent to jurisdiction of the Match Court based on monetary value, or otherwise that the amount would be less than 200,000 or less than 400,000, as the case may be. If I decided to go to the High Court, of course, the court always has a discretion regarding costs, and I could well find that the court would grant me judgment, but then award costs on a Match Court scale, with the result that my client could be out of pocket in given circumstances. Okay, that's always been the position, but this case then said, no, you should go to the Match Court. You cannot come to the High Court if the Match Court can hear the matter. That is from a cost-saving point of view, as well as the promotion of access to justice. And then furthermore, this case then decided that the High Court can of its own accord refuse to hear a matter and refer you to the Match Court, or even the local division, where that division would have jurisdiction. This was taken on appeal, and this case was followed to some extent in the Eastern Cape High Court. Oh yeah, somebody asked me about these references or notations of the cases that I referred to. This ZAECGHC, all of these cases, as far as I could, comes from the SAFLI, S-A-F-L-I-I website. It's a good website. They report by far the quickest and most of the cases, which is sometimes a blessing, sometimes not. They tend to report just about every case that they can report, and it takes a lot of reading to find out the one or two that's really reportable or should have been reportable. But yeah, it's very up to date, and so if you just Google SAFLI, S-A-F-L-I-I, you get there. Yeah, and the abbreviations that we use is, so if it's a South African case, it'll be ZA and then the division of the High Court. In this instance, it's Eastern Cape, and then the G would have been for Grahamstown High Court. That's the seat of the Eastern Cape High Court. All right, so in the case of Gauteng, you would find ZA, G, and then Pretoria High Court, PHC. All right. All right, they didn't go quite as far as the Tobiani case, but they said as far as the NCA is concerned. Remember, the NCA did not interfere with the, well, no, let's put it the other way around. The Match Court, when they included matters regarding NCA under the jurisdiction sections, there was no limit set to the monetary maximum of such a claim. This is now limited, of course, to National Credit Act matters. So there where it says, subject to the amount determined by the minister from time to time. And then we know at this stage it's 200,000 Rand in the district court and 400,000 in the regional division. There is no such a limitation. So you could be hearing Credit Act matters of millions in the Match Court. Nothing preventing that. So the Eastern Cape Division then said that as far as that is concerned, now credit matters falling under the NCA, that should be done in the Match Court, in the Match Courts in the Eastern Cape. So I didn't go quite as far as to say that the High Court may not hear matters of that could have been heard in the Marriage Court, save for National Credit Act matters. Okay, so that was the case law that we dealt with. And then Western Cape Division followed. Number of cases heard at the same time, sort of a consolidation of cases. Okay, and then the SCA had opportunity to look at this again, and on the 25th of June this year, it brought out the judgment. And it held that the High Court must entertain matters within its territorial jurisdiction, even if it falls within the jurisdiction, monetary-wise and otherwise, of a Marriage Court, if it is brought before it, because it has, like it always had, concurrent jurisdiction with the Marriage Court. And that the plaintiff, whose dominus litis, could choose whether to approach the High Court or the Marriage Court. And then again, the main seat of the High Court, let's say the main seat is in Pretoria, and it has then concurrent jurisdiction with the local division in Johannesburg, that such a division cannot refuse to hear it and refer the people to the High Court in Johannesburg. And as for the arguments of cost effectiveness, or and in a sense then also access to justice for financially distressed people, the court ruled that there is no obligation on financial institutions to consider this when they approach the court. So the mere fact that I think that the High Court could grant costs on Marriage Court scale, for instance, that could be a deterrent, but there's no obligation on such a credit provider to then take into account cost implications or even access to justice implications. Yeah, it will be interesting if this would find its way to the Constitutional Court, what they would decide. I couldn't get hold of the relevant people here to find out if they contemplated any, or if perhaps it's even pending, simply because, like often happens, is had this gone the other way, you would most probably find that the credit providers, they have deep pockets. They can litigate all the way to the Constitutional Court if necessary, whilst your consumers often, you know, once you've lost the appeal, it's the end of the road. You simply don't have the money or the access to funds to take the matter to Constitutional Court, unless you're being assisted, like we'll see in some other cases, by a legal aid clinic or pro bono office of some law firm. All right, then of course the other one that we dealt with previously, National Credit Regulator versus Standard Bank of South Africa. This was about what was popularly known as money grabbing, but more correctly perhaps than the right of set off in the common law. So if I would owe you money and you would owe me money, then you had the right to set off the amount that I owe you to the amount that you owe me. So in practice in the banks, I failed to pay the installment on my vehicle financed by them, but I have a positive credit balance in my current account, and then they would transfer that current account the amount from the current account into my vehicle finance account or into my credit card. And that's where they would grab the money. That's where the term money grabbing came of, more correctly than perhaps from the common law, set off. Now, in section 124 and also section 90 sub 2 of the National Credit Act, there was some, well, some people interpreted that brought an end to the right of set off, the common law right of set off, because it was now very limited. It was simply, unless the consumer agreed or consented to it in writing and specifying the amount that you could take, you could not. So very much like it would have the situation of a debit order. There I authorized the bank to, on a monthly basis, say, take a specific amount from one account to use for payment of another account. And this, of course, was exactly the finding of the Gauteng provision of the High Court, that set off as far as, of course, set off, I must always remind myself, just to now and then qualify, we're speaking National Credit Act and limited to National Credit Act only. But set off as far as credit agreements falling under the ambit of the National Credit Act is concerned, cannot happen, except in very limited circumstances, which is not the same as the common law set off. And then I heard that I made inquiry, Standard Bank decided not to appeal this decision. So that is then the existing law. You cannot have set off as far as agreements under the National Credit Act are concerned. All right, then the one that everybody was waiting for, and again, for the sake of those people who did not attend in the seminar or the webinar last year, this is all about costs, legal costs, costs of credit, interest, etc., etc. So I'm going to give you a quick background. So that we understand where the case comes from, or the judgment comes from. In the process, we're going to quickly have a look at the common law in duplum rule, then section 1035 of the Credit Act, of course, and also section 101 costs of credit, that section dealing with costs of credit, and more specifically, collection costs as defined in section 101 sub G. And our point of departure would also be the Nedbank Limited versus National Credit Regulator declarator of coming right back 2011, where they tried to clear up a lot of these uncertainties created by the bad draftsmanship of the Credit Act. Okay, and I know this is now trite for many of you, but just by way of background, the common law in duplum rule simply means that unpaid interest stops running when that unpaid interest equals the outstanding capital. So I owe you 10 Rand, I fail to pay, interest on that 10 Rand starts to run and keeps on running, but stops running when it reaches the 10 Rand that I owe you. Okay. And interest, the interest portion there never loses its character, even when added to the capital. So we capitalize it and we say, oh, well, it's now part of capital. No, there is case law dating way back 1991 and 1997 regarding this. Okay, and then of course, in the common law, the in duplum rule ceased to operate or was suspended once legal proceedings were instituted. Okay. In the Paulson versus Slipknot Investments case, 2015, the court, as it can, the Constitutional Court, that's our reference there, ZACC would be Constitutional Court, who has a duty to develop the common law, and as far as it's necessary, to give effect to the principles in the Constitution, declared that this induplum is not suspended by the institution of legal proceedings. So, in other words, despite legal proceedings having been instituted, once the unpaid interest reached the original unpaid amount or the outstanding amount, the interest stops running. Now, in section 1035 of the NCA, you'll remember some people like Professor Otto called this the statutory induplum rule. This section stated that despite any provision of the common law or of a credit agreement to the contrary, the amounts contemplated in section 101(1)(b) to G that accrue during the time that the consumer is in default may not exceed the unpaid balance of the principal debt. Okay, so I borrowed 10 Rand, I repay 2, I owe you 8. Now, in common law, the interest on that 8 Rand will stop to run when it reaches 8 Rand itself. Now I owe you 16 Rand. However, this section went one further to say not only the unpaid interest, but all the costs dealt with in section 101(1)(b) to G would stop running once that, with the interest, exceeded the unpaid balance of the principal debt. So now it's not only the interest, but also all the costs. And costs, of course, section 101, apart from the principal debt that you have to repay, they would include things such as initiation fee, the service fee, that's your admin fee every month, interest, of course, credit insurance, default administration charges, which is that section 129 later costs of that, and then collection costs. That's the term used, and we always thought that collection costs, as dealt with in the NCA, basically meant the cost of enforcement of a credit agreement. In other words, legal costs. So collection costs may not exceed the prescribed maximum for the category of credit agreement. It may be imposed only to the extent permitted by, okay, that's not so important now. Collection cost means an amount that may be charged by a credit provider in respect of enforcement of a consumer's monetary obligation under credit agreement, but does not include a default administration charge. That's our section 129. All right, so then in Nedbank versus National Credit Regulator, there was a further very important decision made or judgment given. We know that interest cannot exceed unpaid balance at the time of default. But in the common law, if I can get back to my example, if I borrowed 10 Rand and I repaid you 8 Rand, and now I stop paying default, interest would run until it reaches 8. Should I, and then it stops running, should I thereafter make a payment of 1 Rand? It will be utilized first for the interest, of course, and then interest should I then again fail to pay, would start running again until it reaches the default amount of 8. Okay, so this case then decided that interest, until it is paid off to such an extent that it is now 0, that we're back to the default amount, will not run again. So any payment made during the time of the default, which does not have the effect of ending the default, simply reduces the principal debt. Okay? All right, and then there was some debate about, would this include legal fees? attorneys' fees, advocates' fees, fees payable to the sheriff, and so on. So the University of Stellenbosch Law Clinic and others, Summit Financial Partners, approached the court for a declarative in this regard. And the court, the Western Cape Division, declared that collection costs as referred to in Section 101 and defined in Section 1 includes all legal fees incurred by the credit provider in order to enforce the monetary obligations. So all legal fees, whether before, during, or after litigation. So even your collection commission, once you have a judgment, would still form part of that collection costs and would, very much like unpaid interest, would stop in the case of the common law in Duplum, would stop when all of this reached the same amount as the default amount. So that would simply mean, in practical terms, that credit providers would perhaps be reluctant to collect because they could easily be out of pocket. Because once they start collecting all of the collection costs, including the legal costs, the initiation fee, all of that, when it reaches the default amount, it stops to run. But you're still going to charge your client for the work that you do. So it'll be coming out of the credit provider, or let's say the plaintiff's pocket, and he will not be able to recoup that from the consumer. And to make it clear, this 1035, right, it stops running, the statutory inducement plus payments made will not have the effect that it starts running again. So will apply for as long as he remains in default, irrespective of whether judgment or judgment was granted or not. Make it even clearer, all legal fees, including fees of attorneys and advocates, comprise part of the costs in terms of Section 101, and also thus forms part of 103 sub 5 limitation. All right, so this judgment was not unexpectedly appealed by the Legal Practice Council and Bayport, credit provider, which of course suspended the impact because of the pending appeal. So that's why you guys could still charge what you charged as before. Even in Credit Act matters, there was this pending appeal. Now the NCA eventually heard this heard argument on the 7th of September, and just a few days ago, that buggered us around a bit with our preparation. We heard that the NCA upheld the appeal, and it is now reported as Bayport Securitization and another, which is your Legal Practice Council, or our Legal Practice Council, versus University of Stellenbosch Law Clinic and others. I called my colleagues at the Legal Aid Clinic, and I asked them if they are planning to take this matter to the Constitutional Court. And the answer I got is that they're studying the judgment and have not yet decided whether to take the matter to the Constitutional Court. I can remember right in the beginning when this action was instituted in the Western Cape, both parties declared that this matter will go all the way to the Constitutional Court, whatever the decision of the Western Cape Division, or for that matter, the Supreme Court of Appeal. But we'll see. I can't give you any further information apart from the judgment itself. But you can check on the Legal Aid Clinic's website from time to time. They will announce there when they decide to, if and when they decide to take this to the Constitutional Court. You have the website there. Okay, so what the Supreme Court of Appeal now said in Bayport Securitization versus Stellenbosch Law Clinic, or more correctly, I think Stellenbosch Legal Aid Clinic, that collection costs is to be given its common law meaning, and then they draw a distinction between the collection fees charged by an attorney prior to litigation, your soft collections, your letter of demand, your telephone calls, and the costs awarded in an action to recover the debt, your costs of litigation. And the Supreme Court of Appeal said the legal costs, strictly speaking, legal costs, that part of collection costs, commence with a summons and do not allow for pre-litigation costs to be recovered from the losing litigant. Okay, so if costs are awarded against the losing litigant, the soft collections or that type of cost is normally not part of the amount to be taxed. It starts with taking of instructions and the like. The judgment entered is for the capital sum fixed at a particular date together with interest. And then they come to the conclusion, thus 1035 does not apply post-judgment. All right, so legal costs in as far as collection costs are concerned, payable by the credit provider to his attorney will then form part of collection costs, but not once litigation has started, not that taxed bill of yours. Okay. All right, perhaps one other one also from this year to report on is Mercedes-Benz Financial Services. This is the NCR. This is a National Consumer Tribunal case. That's ZANCT is South African National Consumer Tribunal. The NCR, the regulator, took Mercedes-Benz Financial Services to the regulator and by way of a compliance notice, or rather, let me rephrase this. The regulator issued a compliance notice to Mercedes-Benz to tell them that they cannot, in terms of the Credit Act, charge these on-the-road costs over and above your purchase price, plus then interest and so on. Because that is added and it is not allowed in terms of the National Credit Act as costs of credit. Now remember, Mercedes-Benz Financial Services is a credit provider, of course. The regulator came off second best here. The tribunal said that on-the-road costs represent expenses and fees actually incurred by the dealer on behalf of the consumer, and then the consumer is debited with that. It's not dependent on the transaction being cash or credit. So even if I buy that Mercedes-Benz cash, NATIS costs, costs of all these on-the-road costs, number plates, license, registration documents, that initial fuel, etc. All of that is still payable. So it's not, it was found not to be credit, and thus the on-the-road costs was not in contravention of the Credit Act. And then the result was that the NCR compliance notice was set aside. Now, I think why the NCR took them on is previously This is now 31 May 2021, but you'll see that previously the very same regulator took on Volkswagen and financial services to the Consumer Tribunal, and there they were successful. This was in 2019. However, this year, 2021, BMW was successful in having the compliance notice set aside. So, and then followed Mercedes, of course. All right, so I think this is now sorted. I think those of you acting on behalf of people providing these extras, obviously the test is perhaps one of the tests that one can apply is, is it really costs of credit? Or is it perhaps something else, some other charge or fee that would also be payable even if I buy the item by way of a cash transaction? And you can also read further, the cost of credit, two people that are really very knowledgeable in the Credit Act. The one is Professor Corleah van Heerden, the other one Professor Stefan Renke. I used to consult with him quite often. Now that I'm in Stellenbosch, no longer so much, but they wrote an article on cost of credit and specifically regarding road fees, administrative fees or handling fees. Okay, the last one I want to have a look at before we have a convenience break is Lewis Stores versus Summit Financial Partners, 25 June 2021. Okay, so and this we've dealt with in previous seminars. So I can complain to the National Credit Regulator, and then the regulator will investigate. There's a wide variety of complaints that I can have as a consumer or as a credit provider for that matter. I complain, and then they investigate, and then they come to a decision, either to proceed with the case to the Consumer Tribunal, or otherwise not to proceed. And then they can issue a notice of non-referral. I think this is similar to the public prosecutor, a National Prosecuting Authority deciding to prosecute or not. And then I can obtain a noli prosequi certificate, and then I can engage in a private prosecution. Not that I'm an expert on criminal law by any means. I think the last time I was in criminal court was about 32 years ago, and that was not even as a legal representative, that was as an accused. Some speeding fine that I got that I wanted to query. Okay, so so this is exactly what happened here. Summit Financial Partners, who is an activist organization, they were also a part of the Stellenbosch Legal Aid Clinic case that we've just dealt with the 1035. They took Lewis Stores, or Lewis Stores basically wanted an order regarding, Summit Financial Partners wanted a directive from the regulator. The regulator investigated, decided not to proceed with the matter, and then Summit approached the Consumer Tribunal directly to proceed against Lewis Stores. And then Lewis Stores took this decision of the Consumer Tribunal to allow Summit to continue with the matter took this decision to court and said, well, this is so illogical, I think that's the word they used, that they didn't have the opportunity to put their side of the story to the tribunal, who's now decided to proceed. And then the Supreme Court of Appeal agreed with the Gauteng division that this section 141 sub 1 sub B that empowers the National Credit Regulator, the National Consumer Tribunal, to grant leave to refer a complaint directly to the National Credit Regulator, where it has issued a notice of non-referral. This does not require formal application or a public hearing for that matter. And they emphasized the wide discretion that the tribunal has in this type of granting leave to refer directly to it. Any complaint where the regulator has decided not to refer. Just by the way, they also had to deal with the question if this tribunal decision to grant leave to refer directly to it, if this was in fact appealable at all. And they found that it is not. It's an interlocutory order. You will have your day at the tribunal. So this is an interlocutory order and therefore in line with the normal practice and procedure and law, and not appealable. And nevertheless, despite deciding on that, they nevertheless said, let's have a look at the, had it been appealable, did the Consumer Tribunal go beyond its powers? And then they found no. I think simply to avoid further litigation in this regard. Okay, so there you have it. It's very much of a procedural nature more than anything else, but I mean, that's what we're busy with from time to time, isn't it? The procedure becomes just as important as the substantive law. Okay, it is 10 to 12 now. I think this is perhaps a good time to have a 10-minute or so break, convenience break, and then we can come back. And we'll start with the questions received. And I'm quite sure that we will finish well before 1 o'clock. So if you have an urgent question, you're welcome to, during the break or even thereafter, take your own little break and forward it to me by way of an email, or otherwise to any of our friendly ladies at LSSA Lead. You also have their particulars, and then I'll see if we can deal with that as well. Otherwise, just a reminder, the slides available now. You have them. You can go to the eLeader platform, go to NCA Seminar, to the material, and then to sources. The slides of today, as will be amended in light of the questions that we'll be dealing with and not be dealing with, will only be available towards the end of next week. And you are free to send in further questions until I say it's 12 o'clock on Saturday afternoon, not Saturday night. Even the wicked must rest, you know. All right, so let's be back in 10 minutes time. I think by then let's say 10 past, sorry, no, 12, let's say 5 past 12, if we could be back then. Thank you. Right, we're back. Trust you enjoyed your little 12-minute break. Just one or two things that came up during the break and I could access. I see Alicia Naidu is complaining she cannot get to the slides on the eLeader platform. I really don't know what to say because I saw one of our colleagues, Marika Ferreira, reported that she has access to the slides and that she even printed them and so on. Just one thing, Geraldine asked about it. The slides we're speaking about are the slides that I used yesterday. Okay? So you won't be able to find today's slides. You can try on the eLeader platform, of course, and then go to NCA material and then under sources. You should find it. As explained in the beginning, and some people might have missed this who perhaps joined us a bit late, today's slides will only be available towards the end of next week, as I can see that I still have to work on many of the questions received from you guys, even up to now. I've just received another 2 questions. So I intend not to just share that with the person who asked the question, but also with the whole of the group. And for that, I'll need either to do some further research in some instances, or otherwise just simply to amend or expand my slide presentation. Okay, now let's continue. Just a further new development. I think one of the cases that we had a look at on previous occasions was the situation with Moneyline Financial Services and the fact that the NCR applied for them to be deregistered. This was, of course, well and widely reported in the popular and also financial press. Moneyline was part of the Cash Paymaster Services Net1 company that infamously handled the SASSA payments from 2011 to 2018. Lots of complaints there that they had access to SASSA payments and beneficiary information, and that they sort of applied money grabbing by deducting from the SASSA payments monies due to some of their subsidiaries, specifically Moneyline. This matter has apparently been settled out of court, so Moneyline will effectively continue, but I'm quite sure they will not continue with the practices that they employed or allegedly employed, because there's no finding in this regard. Okay, you can have a look at that, and we'll watch this space for further developments. Okay, like yesterday, most of the questions that I received pertain to registration of credit providers. Most of the questions that I received today was about the consumer who finds himself in the difficult position that he's under debt review and he wishes to exit. And apparently there is no way of exiting debt review. Once you've been declared over indebted and you pay, then Section 71 makes provision that once you have settled all your debts, and that section was amended from all the debts to say, save for mortgage and long-term debts, you can apply to your debt counselor for a clearance certificate, which will only be issued once he has received sort of paid up letters, although that's not provided for in the Act, from the credit providers confirming that you have now settled all the outstanding amounts, save, like I said, for mortgage and long-term. And that, yeah, people's circumstances would change. They would be able to exit debt review purely from a financial point of view, but not able to settle all their debts. They're up to date, their circumstances have changed. Whilst they're under debt review, they cannot access further credit, of course. They have a bad credit record. Of course, it's reflected at the credit bureaus that they're under debt review and so on. So then, of course, what happened, and I simply don't have the time now. Again, we dealt with this last year and the year prior to that. People would then approach the High Court for an order to be declared not over-indebted anymore. And in Gauteng, there were 2 or 3 cases where this was in fact granted. This was in contrast with the position in the Western Cape and also in Natal, KZN, where the High Courts refused the relief sought in those applications. This then led to a declarator from the High Court in Gauteng, full bench decision, and we've received, you have 3 questions regarding alternative ways of getting out of debt review. There's a very good question from our colleague, Mrs. Garlip, regarding the abuse of the process and so on. So I will get back to this, but let's just give this the present situation, as I think it is now accepted by just about everybody. This is the declarative that we had in September 2019. I'm just going to go through it very quickly. Because I can see from the questions that not everybody is aware of this case, or alternatively did not attend the previous year's webinars. Okay, so the questions raised that had to be answered was, is a High Court able to make an order confirming that an applicant is no longer over-indebted, where there is no valid declaration of over-indebtedness before court? Oh, in other words, this debt counsellor as applicant and the consumer as first respondent and all the credit providers as further respondents, if they apply to court for an order, and then the process is started and you cannot enforce. Now the question is, if a court has not made, a match court has not made a finding of over-indebtedness, and there's no valid court order declaring this person to be over-indebted, can the High Court then confirm that this debt review process be stopped? As we know, from way back, the Rogier case, I think that's about 10 years ago, a debt counsellor cannot withdraw the application once he has embarked on this route. The High Court finding then was no, we cannot do that. The second question was, okay, so order has not been made, the application is perhaps pending, and now circumstances have changed. And now this consumer no longer wishes to continue along this road of being declared over-indebted and so on. And then the court said that the correct procedure would be to place the application, to enroll the application, but then from the side of the debt counsellor to bring this new information to the attention of the match court. And the same would apply, of course, the consumer himself would be able to, by way of filing an affidavit as first respondent, would be able to convince the court that circumstances have now changed, that this application or the order that was applied for, or that is applied for, should not be granted. Okay, so, and then, of course, once the order has been made, there is now a court order declaring him over-indebted and rearranging his payments. Then the only statutory remedy is Section 71 regarding the termination of this debt review. Yeah, and then the further declaratory question, that is basically just confirming what I just said. And also the alternative to try and work via the common law would also not work, because the concept of over-indebtedness is a completely new statutory creation, and it is not dealt with in any similar fashion in common law. So there's no ways that one could bypass Section 71, relying on common law and inherent jurisdiction of the High Court and so on. By the way, that I saw that one of our colleagues, is it now, I think Brigitte Schultz, said during the break, made a comment in the comment section. So does that decision that I spoke to, that was overturned in the Supreme Court of Appeal, the Tobayane decision, does that now mean that seeing that a High Court must hear matters, it has concurrent jurisdiction of a match court, can I now apply for debt counselling or debt review in the High Court, in the Western Cape Division of the High Court? I'm afraid not. You see, basically our point of departure is the High Court can hear any matter unless it does not have the authority. Its authority has been taken away, or by way of statute it never had the authority. Whilst the match court can hear no matter except where it's been granted the authority. Okay, so as far as debt review is concerned, debt counselling, debt review, it's a statutory process. It is set out in both the National Credit Act as well as in specific regulations pertaining to debt counselling. And there is quite clear that the court that has jurisdiction is the Magistrates Court. And with the Amendment Act that we dealt with earlier today, we will also now find that the National Consumer Tribunal will have jurisdiction in these matters, but not the High Court. All right, so no, you won't be able to go to the High Court. Very much like we could say that in certain matters, the High Court has concurrent jurisdiction with some of the other specialized courts, but where it's expressly excluded, or it's clear from the wording of those statutes that some other tribunal or court has jurisdiction, I'm thinking labor court, I'm thinking competition, and so on, then you cannot go to the High Court. Yeah, the Judge President also raised this question, does Section 71, in other words, you must make good on all your payments, you must not owe anything apart from on your bond if you're under debt counselling. Is that sufficient? Does it afford an adequate remedy for people who want to get out of debt review? And obviously, the court said, well, we're not legislature, so we're not going to entertain this question as such. It is for the legislature to do so. And that the High Court exercising powers in this regard would be inappropriate. So this then confirmed the position as was the position as in the Western Cape and in KZN. And I think it is now generally accepted, apart from the fact that so yeah, here you have the judgment that no interpretation of the statute can support the relief that the High Court may order a release. Sorry, I'm just having a problem here with the slides. Yeah, the question that Geraldine posed, I'll be dealing with that in far more detail. But she was referring to Form 17W, where the abuse of this process, where people would apply for debt counselling. I'm not speaking application to court, apply to the debt counsellor, and then give notice in this regard, and then withdraw in terms of a form created by the regulator, 17W. Now, my position on this is that this 17W form is ultra vires. It might be handy, and it might be an effort to assist in the process, but there's no provision in the Act for the regulator creating forms and policy that would otherwise require the minister to do so, or otherwise Parliament. If it's a change to the Act, it's Parliament. Otherwise, the minister is in a position to, by way of making regulations. And I quote there from chapter 9 of the NCA, the general provision, section 171. Minister may, I'm underlining minister, may make regulations in consultation with the regulator, including forms, time periods, manner of form of participation, etc. And the Act further provides that before making such regulations, the minister must publish the proposed regulations for public comment. And once the regulation is then promulgated, it must be by way of notice in the Gazette. Now, the only forms, there's a lot of forms in the annexures as annexures to the Act, but the only forms dealing with debt counselling that went this way was Form 16, 17.1, 17.2, 18 and 19. So 17W, 17 withdrawal, I suppose, is a creature of the NCR and not in accordance with the Act. So the question regarding alternative ways of exiting debt review, I'm afraid that we have section 71, and then perhaps I've already referred to debt consolidation, which basically will then mean that you comply with 71 because you now pay off your debts. You have a new debt, but that's not falling within your previous over-indebtedness schedule, your restructuring schedule. Of course, we still have rescission of judgment, but that is limited to cases erroneously sought or granted, or where there's an obvious error in the judgment, or made as a result of a mistake common to all the parties to the proceedings. Now, I know rescission has been successfully used, but this is more in the case where you have all sorts of, let's call them entrepreneurs, I don't want to use the correct word, that approaches people under debt counselling and then tell them we'll be able to get you out of debt counselling. And then, yeah, a few hundred further rand down the line, they say, no, sorry, it was refused. Okay. Where we did get people out of debt counselling, a partner from the Section 71s, is in those instances where people were placed under debt review without them even knowing it, or without giving specific instructions. People would advertise, mostly on the internet, and say, you have debt problems, we can solve it, we guarantee that you will pay less every month, you will make it now, and so on. And then these people apply for further information, and they send all the information, and next thing they hear is, okay, your payments have been lowered, you are now under debt counselling. And lots of that is simply fraud, or perhaps a mistake common to all the parties concerned. So those orders have been set aside by way of rescission of judgment. Okay, people, please. We have again people not muted. If you want to read more on this, Van Heerden and Coetzee, Unintentionally Trapped by Debt Review, an excellent article, not only an academic, very strong academically, but also addressing lots of practical questions. Okay, then we had questions yesterday. To some of these I'll get. You mentioned the duties of credit providers. What are the most common instances of not complying with the NCA? Well, I didn't do a calculation and keep stats, but failure to register is one. Failure to pay renewal fees is another one. Reckless lending, still very prevalent. In other words, granting credit to people who should not have been granted credit. Failure to keep records, exceeding the maximum interest rates, entering into unlawful agreements or including unlawful provisions in the credit agreements. And this is where attorneys should perhaps have a look at the credit agreements that their clients use and check that against Section 90 of the Act. I find that in many of these standard credit agreements, we still have unlawful provisions. Failure to cooperate with the NCR once they investigate and so on. The list is really endless. So what I did is I made a list of all the 2021 cases from the National Consumer Tribunal and regarding misdemeanors and so on of credit providers and also of debt counselors. So the next, and you can see there's quite a number of them. This is just from March this year to June, well, beginning of June, when my slides were supposed to be submitted to LSSA lead. And you can see there's a number of them. The list continues. I then added some in July and August. If you read any of those cases, you'll get a very good idea of where credit providers fail to comply. Often, as you can see from the names of these credit providers, they tend to be micro lenders or smaller lenders. There are also a number of debt counselors that engage in all sorts of dubious practices. I found 4 of these cases just in the past few months. And remember, what happens or what actually finds its way to the National Consumer Tribunal is but a portion of what happens in practice. Very many transgressions of the National Credit Act by both credit providers and debt counselors. Okay, so the questions that I've received since yesterday, simply too many to try and deal with in the next few minutes. As I told you, I will, during the course of next week, add additional slides with including these questions and expanded answers. I've put the questioners, the colleagues who asked questions, names there so that you can check if I have yours. 1 or 2 that came in now, of course, won't reflect on this slide. I think Mr. Gill asked a question regarding Section 87, sub 7, sub C, sub 2. I think, Mr. Gill, that should read 86.7, but I know what you're getting at. This subsection makes provision, not in debt counseling, apart from the normal one where we restructure the debt by extending the time period under the credit agreement for payment and thus lowering the interest, lowering the monthly installment. This also makes provision for where we can suspend for a time period payment. And his example is a very good one. Somebody who has suffered financial loss and is in dire straits because of the airport company where he's working not flying. So he wasn't retrenched, but they simply weren't flying. And we saw that. And of course, then with that comes no payment or decrease in payment, and now they find themselves in problems. But once they start flying again, this pilot or air hostess or whatever he or she is will resume their position, financial position as far as income is concerned, will get back to normal. Yes, I think that would be an appropriate circumstance to ask for 86.7C2 for a period then perhaps not exceeding too long. But as I've indicated earlier, you don't see this too often. It's normally just the review. So you might find that you have opposition from credit providers who will now not be getting a reduced amount every month, but nothing at all for a period. But I think, like in any court case, you should be able, if properly formulated in your affidavits, able to convince the court that this is the best in the circumstances. As it is, if you embark on this line, you know, from the time where you give notice of your intention to have him placed under debt review until the matter is actually heard, and remember 8610, section 8610 was changed. They can no longer terminate after 60 days or after 90 days once you have enrolled the matter. And then there's a waiting time for this to be heard. By then, perhaps you have solved, your client has solved his problem, because he is effectively getting a suspension or a moratorium whilst the application is pending. Then Ms. van Skalkwyk asked fees and disbursement in terms of the Contingency Fees Act. Okay, so the Contingency Fees Act regulates fees charged by, unlike in the common law where we could not say that we'll only charge fees if we're successful or partly successful. So this Contingency Fees Act makes provision for exactly this. It has its own requirements, of course, and the amount that you can charge then, if you're successful, would be more than your normal tax costs or attorney and client costs, as long as it does not be more than 100% more. In other words, twice as much. And then there's a further limit that you are not allowed to get more than 25% of the amount of the damages awarded to your successful client now, whichever is the lesser. And I had the opportunity to, this was a question, by the way, in the immediate past admission exam. You guys should tell your candidate attorneys, many of them simply said you can get 25% of whatever is awarded. No, it is not that. It is either 25% or not more than twice your normal fees, whichever is the lesser amount. We don't want you guys ending up in Australia like our colleague Bob Roff, who didn't adhere to this. Okay, so then she wanted to know if this falls within the realm of the National Credit Act. My immediate answer is no, because the fees, the whole structure, everything is done in terms of not the National Credit Act, but a separate piece of legislation, the Contingency Fees Act, where you do pay on behalf of your client disbursements. You will be able to recover that, of course, but I think there might be a danger, and I would like to research that a bit more, where I say, okay, until this case is finished, I will in the meantime pay counsel. But then when you repay me for what I've paid counsel, for instance, or some other disbursement, a medical doctor or whatever, I'm going to charge you interest. I think then you might find yourself placing yourself within the normal position where somebody borrows money from you and he has to repay you at a later stage plus interest. So be careful of that one. But I'll when I get back to you all, I'll have an answer on that. Then Ms. Loebscher wanted to know about Homeowners Association levies and the NCA. All right, there's no decided court case that I could find on Homeowners Association levies. As far as NCA is concerned, there are a number of cases, of course, but not specifically. I found one or two where it was obiter dicta, where judges said, in the one case they said this is quite an ingenious argument, etc. And one that said it's similar to sectional titles, and so on. So we have the case law on sectional titles, the Mitchell case, and the Frenolin case, and so on, and Geary case, where it was decided that sectional title levies are not credit agreements and will not fall within the ambit of the NCA. And I suggest the same would apply to Homeowners Association levies. There's no real extension of credit or delivery of goods or services on credit and deferral of payment. And homeowners associations, of course, are either non-profit companies in terms of the Companies Act, or I believe you can also get it common law associations of people, and then based on their constitution. So I don't think in any way that those levies could be attributed to a credit agreement in terms of the National Credit Act. Then she also wanted to know something about the 1 million rand threshold, what we dealt with yesterday. So if a juristic person has either an asset value or a turnover of more than R1 million, and you enter into an agreement with such a juristic person as consumer, in other words, they, the consumer, the juristic person is the consumer. So it's a company borrowing money from a bank, for instance. Then the Act will not apply to that agreement. Now, what she wanted to know is this threshold, when do we look at it? Okay, if we rely on the 1 million rand asset value, this will be as on date of the agreement, the assets then. The fact that it may at a later stage decrease will not affect, have no effect in this regard. If we look at the turnover, it would then be for the year preceding the entering into the agreement. Okay. Then she also asked a third question regarding the 250,000 rand threshold, so-called large agreement, 250,000 rand or above. That you will have to follow up with me. I'm going to ask you a question or two in return, and then that could impact on our answer. So here the situation is, if I understand correctly, it is a small juristic firm. So in other words, they have turnover and asset value of less than 1 million rand. They enter into an agreement which is then 250,000 rand or above. Obviously, in terms of Section 4 of the NCA, that agreement, small juristic person but entering large agreement, mortgage or 250 or above, will not fall within the NCA. But now what if at a later stage they enter into, they buy stuff again, not for 250,000, but let's say 25,000. Okay, if we can say that's part of the original agreement, in other words, if we can bring this into context and say we have an open account where the limit is more than 250,000, and then you buy from time to time, those accounts, and you do not charge interest, of course, from the day where the people buy. You charge interest from the date set for payment of the account. Very much like an attorney, isn't it? You, on an ongoing basis, you provide services to me. If you've drafted your particular claim, you can debit your fee, but in terms of our agreement, I'll only pay the end of the month or after 30 days. You're not going to charge interest on the amount that you debit for the particulars of claim. From date of drafting of particulars of claim or filing it. Okay, so if you only start charging interest on those small amounts, after I'm in default, then of course it becomes an incidental credit agreement or an open account. So, and it's not a credit agreement that attracts the attention of the National Credit Act. Okay, Mrs. Golub, you asked a very good question regarding default judgment in NCA matters by the registrars, and I'm aware of conflicting judgments in this regard. I will deal with that. I can perhaps just quickly say that I called a number of attorneys who I know is very active in Credit Act matters in the High Court. I could only get hold of Gauteng and Limpopo. This was last night at some stage. And Gauteng says that they have no problem in obtaining judgments via registrar in these Credit Act matters. Let me just quickly get there. He actually sent me an email to confirm, so now I have it in writing as well. I'm going to just get hold of that email. Anyway, I'll be dealing with that when I answer the question. Just basically, we know that the registrar is entitled to grant default judgments in terms of, is it section 31(5) and 5A and B of the rules of the High Court. In terms of that rule, he can either grant judgment fully or partly, or he could refuse judgment and query the request for default judgment, or he could postpone it, or of course he could refer the matter to open court. Now, the attorney in Pretoria, Max Tupel and Ross, and they deal with a lot of these things, they say that we normally we don't have a problem. We even if it's about damages, we simply file a so-called damages affidavit with the accompanying certificate of balance. This is now, for instance, where you have a return of a motor vehicle and then you postpone that prayer regarding the damages until that vehicle is sold or evaluated. So no problem as far as that is concerned. Obviously, this will not apply in the case of immovable property, foreclosures, bonds, and so on, because there's lots of case law on that can only be heard by the court and not by a registrar. Now, the attorney in Limpopo that got back to me on this said that apparently because of a shortage of registrars in Limpopo, all National Credit Act matters are referred to their great frustration to open court. So yeah, perhaps colleagues can also let me know what the position is in your divisions. Basically, I cannot see a problem with a default judgment on the National Credit Act to be granted by a registrar. Right, then. Okay, Ms. Golub, we'll also get back to the, not today, but to the debt counseling process. That is simply an abuse by debt counselors and consumers to apply and then to withdraw and then to apply again and then to withdraw again and keep on keeping you at bay. We will come up with some very practical solution in this regard. Yeah, the same with Mr. de Klerk, debt review, the creditor not included. I would simply continue if I'm not included in that court order. Now, perhaps the starting point would be to call the debt counsellor to say, look, I see this guy claims to be under debt counselling. We are not included. Why not? You see, the debt counsellor relies on the consumer to initially tell him about all his or her credit providers. And they can simply forget or conveniently forget about a credit provider. That would be one reason why you're not included there. The other reason is, I've come across this as well, where people deliberately not include certain credit providers and they continue paying them outside of the debt rearrangement scheme. But yeah, start with the debt counsellor, ask him why we are not included, and then they can either apply to have this order amended, which you can then oppose should it be necessary, or otherwise you will then be included. Pre-existing agreements, this is also very good. I've forgotten about the fact that the National Credit Act has been around so long now. It's Act 34 of 2005, remember, and it came in effect in 2007, so it's quite 14 years, 14 years plus. So Ms. Singh asked about a pre-existing agreement, in other words, an agreement that existed prior to the National Credit Act becoming operational. I just want to, so that credit agreement must have been, sorry, I'm just trying to find something here. Just bear with me for a moment. Okay, so that must have been in terms of the Usury Act or some other legislation that was repealed and replaced by the Credit Act. Now, she wanted to know that Rule 12.6 large A that we get in the marriage court, where you have to file an affidavit in matters regulated by statute, that you have complied, right, with the requirements of the statute. What does she say in that thing? She just say the Usury Act, but the fact is that you must not forget about those schedules attached to the National Credit Act. There is a schedule specifically dealing with pre-existing agreements, and then more specifically to which extent does the Act apply to those pre-existing agreements. So this is stated in Schedule 3 under paragraph 4. This Act applies to a credit agreement that was made before the effective date of this Act, if that credit agreement would have fallen within the application of this Act in terms of Chapter 1, if this Act had been in effect when the agreement was made. Now, I'm quite sure the agreement that you referred to about is a credit agreement, and this Act would have applied had it been operational at the time when it was made. So once you've established that, then you can look at the column that they have there, to which extent does it apply, and it seems to me that it applies fully. So if you want to enforce in the terms of in the language of the Act, this pre-existing credit agreement, you would have to comply with your debt collection mechanisms in terms of the Act. So you would have to have a Section 129 letter. You would have to have proof that it was sent by registered mail, that it reached the correct post office. Oh, you know all those things. All right. So in short, I think, yeah, it is an existing agreement in terms of the. All right. Mr. Marais, once off agreement, party seeking utmost possible advantage. Is that allowed? Yes, of course, allowed. If as long as we stick to utmost possible advantage in the sense that we do not do anything illegally. In other words, for instance, charge more than we are allowed to do. So if I'm a micro lender, the maximum interest rate that I can charge is 5% per month, for instance. So if I charge 10%, it's the utmost possible advantage to me, but it is also in contravention of the Act. It becomes an prohibited conduct, etc., etc. Yeah, and where it is allowed, it falls under the NCA. Okay, how would you advise clients to have their agreements falling outside of the Act? I think we dealt with that yesterday. You can't contract out of the Act. If you only, let's take money lending. If you only lend to large juristic persons, it is per se outside of the Act. If you only lend 250,000 Rand or more to small juristic persons, it is outside of the Act. If it is an agreement between family members where there's dependency or interdependency, it's outside of the Act. If it's any of those other agreements, like lease of immovable property, it's outside of the Act. Or a straightforward rental agreement. Okay. So I suppose TMF attorneys, one could say, I only deal with companies, and then I get the directors of those companies to sign a surety. And then that agreement is outside because it's a large juristic person, and I have security in the sense that the directors of that large juristic person have signed surety in their personal capacities, and if the principal agreement is outside of the Act, then those suretyships are also outside. Now, Mr. Weiss shared an experience regarding the external lender, and somebody else also asked. Okay, so this is the situation where if your lender or credit provider is outside of the Republic, but the credit agreement has an effect in the Republic, then the Act will still apply. Now, this will discourage many credit providers, overseas credit providers, to invest or to enter into credit agreements here, and therefore the Act makes provision that you can apply to the minister. And in this case, the minister is the Minister of Trade and Industry, of course. And Mr. Weiss shared experiences in this regard that it wasn't a problem in the past, but now there seems to be delays and backlogs, and they don't really come back to him regarding this. The form that somebody asked about, at the back of the Act itself, there's a large number of forms. Form 1, the very first form, is the form that you complete, and then they might ask additional information to get the minister to exempt your credit agreement. Right, we're nearly there, guys. Just a minute or 5, and then we're there. Ms. Wiggett asked questions regarding, and I'll be coming back to that. It is very good questions. Loans with no interest charged. Normally, that would not fall within the Credit Act. Just make sure. Deferral of payment is, of course, deferral of payment is a requisite, and then an interest or charge or fee regarding the deferred amount. So if my domestic helper says, can I borrow 300 Rand from you? And I say, yes, but then I'm going to, then you have to repay me on payday. And I say, you pay me back 300 Rand, that's fine. That is not a credit agreement. But if I say, but I want interest on that, for argument's sake, I'm going to take 10 Rand interest, then it becomes credit, okay? But not only that, it's now interest or charge or levy or fee regarding the deferred amount, then it becomes credit, or regarding the contract itself, the agreement itself. So if I say, okay, you can sign an IOU, then I forward the 300 Rand to you, you sign an IOU, and then you repay me at the end of the month 300 Rand plus the 10 Rand for this IOU. Then again, there's now additional charge or fee or levy regarding the agreement itself. A mortgage bond, And the specific one that you mentioned is a father and a son, or parents and children. A mortgage bond by definition is a credit agreement. But in your example, where there's no interest charged, and being people then not independent of each other, so they know each other, there's a familial bond, and they're not looking at the utmost possible advantage, obviously, I would be able to argue that this falls outside of the NCA in the sense that it is not really at arm's length. Remember, at arm's length is our defining criteria in the first instance. Interest only on the balance of such a loan, yes, that of course will make it fall within the ANC. And then Ms. Naidu asked questions on ECTA, service of documents electronically, and she gave me a very good tip here. She would contact, and she did, contacted sheriffs of the court to hear if they actually do it via electronic means. And I think the sort of general answer in this regard was yes, where both parties agree to it and has consented to an address, an email address that it can be sent to. And she says they did that especially in the time of COVID and the lockdown, because they wouldn't allow people to, for instance, come and collect summonses at their offices because of the COVID regulations and so on. But yeah, that's something that I dealt with yesterday. I'm looking forward to seeing if that can become part of our law, because you know, if we could have that in the Institution of Legal Proceedings Against Organs of State Act of 2002, then at least we should also be able to have that in the National Credit Act today. Okay, I think that's it. The only concern that they raised with me by the NCA for this year's update was the credit information regulation, that people failed to submit their credit information. Only new thing. And I deal with that in the next 3 slides. So that's it. We also dealt with that yesterday to some extent. Okay, thank you very much. I will be looking forward to receiving more questions and comments. Please, it's very valuable to me if you can share experiences or cases. As I say, I'm not in full-time practice anymore, so you know, I don't really know what happens in your registrar's office or the clerk of the court's office in wherever you practice. So if you share those things with me, it is very, very valuable to me as well. Thank you very much. Looking forward to receiving questions, and then we'll have the slides, today's slides, ready by end of next week. It is 1 o'clock now in the Western Cape, so it's a Friday. So I'm off to do my wine tasting, like you guys would go back to work and have coffee. I'm now into wine tasting for the rest of the weekend, and then we'll have a look at the Credit Act on Monday again. Thank you. Ag, jy behandel 'n ding en dan vra die presies dit. So jy sê jy mag nie op 'n Sondag swem nie, dan vra hy, kan ek op 'n Sondag swem? Okay. So ja. Hierdie jaar. Ek kan seker nou maar die meeting leave, nee.
Ja.
Ek het my, Jesus my ding is nie gebeur nie.